Hey again, everyone. It's Rob Ryder, and it's Wednesday, October 6th, 2021 at 5:29 in the morning. God only knows why I'm up this time doing a video, but, well, because God told me to. That's good enough for me. So, constitutional question ends foreclosure in a New York minute. Just happened, right? Guy filed constitutional question into his court case, and the judge dismissed the case. So let's see what that's all about. And I am Staff Sergeant Robert Allen Rutluski, United States Army veteran, also known as Rob Ryder. And my email address is courtofrecord@aol.com. And, if you don't follow me that closely, some time ago now, it's been 2 months, I did a video on notice of constitutional question and subpoena, having to do with some things I had read in, what was that in? Anyways, let's go find it real quick. In the Florida Rules of Civil Procedure, right, where it said in Rule 1.071, constitutional challenge to state statute or county or municipal charter, ordinance, or franchise, noticed by party. And that was before, you put in an answer or a affirmative defense, right, that, that you should do this first if you had the opportunity. And all it really said to do was, it's on page 20, right, that a party that files a pleading, written motion, or other document drawing into question the constitutionality of a state statute, county or municipal charter, ordinance, or franchise must promptly file a notice of constitutional question stating the question and identifying the document that raises it, and serve the notice and the pleading, written motion, or other document drawing into question the constitution of a state statute, county, or municipal charter, ordinance, or franchise on the Attorney General or the State Attorney General of the circuit, judicial circuit, which the action is pending. So it's this thing about the franchise, right? That a judge has a franchise, right? Having an office is a franchise given to them by the, by the government. And so I was saying, well, we should be able to put in something saying, because I've said before, numerous times now, God, who knows how many times, none of these people have taken the oath to satisfy the 6th article of the Constitution, right, which is found in 1 Stat 23, which we'll look at here in just a minute, because the guy put this stuff in a court case, and it got dismissed, right? That's saying, basically, is the statute constitutional if the people that passed it didn't take an oath to the Constitution? And is the judge able to hear a matter if they didn't take an oath to satisfy the 6th article of the Constitution? Just 2 questions. Well, the guy put it in and the case got dismissed. So, let's start there. That's a good place to start for the day. So if we're going any farther, if you could, it's your donations that keep the lights on and content coming. And if you could, please send a donation to Rob Ryder at AOL.com on PayPal. Or you can put it in the mail to Robert Allen Rutluski. That would be me. 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. Which itself leads to an interesting thing that's going to be part of another video, but I wanted to show it now because I had gotten this in the mail, right? That, these are all indications of the problems we have in our society, where when your public school, right, this is the district, sends mail to me as a resident at this address. Well, how come they don't have my name in here? Right? So go look at mail you've gotten from your school district and see if they put your name in it, because if they're not putting your name, then that's them acknowledging they don't know that you live there. Well, your school district is supposed to have elections, just like all the other elections, right? And you're supposed to be an elector of the school district. But if you're just seen as a resident, they don't know who you are. And so this is one of my next projects, is to get a hold of the school district and find out, well, how come my name isn't on the mail that you're sending me? All right, so that's a whole separate issue altogether. So anyways, this case we're going to look at, right? Again, there's notice of constitutional question and subpoena. And so the case we're going to look at, it's in New York, right? So if you were to Google New York State Courts electronic filing, right? New York State Courts electronic filing, you'll get this hit for e-filing, newyorkcourts.gov, right? When you click on that, it'll take you to this page. And if you go down here to filing page and click on it, well, it'll take you to this page. And if you scroll down to where it says search as a guest, you can click on that and you can do this. And next thing you know, you'll be looking at this page here. All right. Well, the document that the case we're talking about then is 2019 52422. Right. And that's what you would put in right here under case number. All right. 2019 52422. And I suggest you do this because you can see all the documents, right? Here's all the documents that are in there. And you can open them and look at them for free. You can download them, and you can make your own decisions what all this stuff means. But what I can tell you is that the case has been disposed. Well, if you go Google, what does that mean? That means the case is closed. Now, the case was dismissed without prejudice, but it's closed. And we're going to read why the judge closed the case, which is really way down here at the bottom, right? Actually, these 62 and 63 are the exact same document. It's just that there was a motion put in by the plaintiff and a motion put in by the defendant. That's what motion 1, motion 2 are. And these were put in way back here in January, earlier. Right, there's motion 1. So, I mean, this stuff goes all the way back to the beginning. And so basically, this case started in 2019, right? And it went on and 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 on until we get to notice of constitutional questions, number 58, right? Received 9/14/2021, and on 9/29, the judge was writing an order. Actually, she wrote it the day before. So it took her 2 weeks, but it's been dismissed. So what I want to do is read what the judge had to say, and then maybe go look at some of the documents that she's referencing, what she had to say, and we'll see what it all means. So give me just a second here. Okay, so again, we're going to look at whatever 62 and 63 are, which is the same document. Just put it in twice. And it's the decision and order for that index number 2019-52422, in which it was said that the following papers were read on plaintiff's motion for summary judgment and defendant's cross motion for summary judgment dismissing the complaint. And she's basing everything she did on documents 22-46 and 58-60. All right, so, right, I mean, there's obviously many more documents in here before that, but she said she started at 22, which is notice of motion, went down to 48, I think she said, something like that. Whatever, I'm just saying that's where we're at, right? Because you're going to have to go look at this yourself to see what all of it means. I probably won't be able to explain it entirely because just too much to look at and would take too much time in one video. But I do plan on doing a follow-up after I've had a chance to digest this a bit more. Let's get started. So on May 4, 2015, Shelley Jones executed a note endorsed in blank. Well, actually, she executed a note and somebody endorsed it in blank, but we'll get into that later. in the principal amount of $165 and change thousand in favor of Plaza Home Mortgage Incorporated to secure payment of the loan. Shelley Jones and Warren Jones simultaneously executed a purchase money mortgage agreement in favor of Mortgage Electronic Registration System, Inc., acting solely as nominee for Plaza Home Mortgage, Inc. The mortgage encumbered certain premises with an address assigned. Mears assigned the mortgage to PennyMac Corp., which in turn reassigned the mortgage to the plaintiff, PennyMac Loan Services, LLC, on April 17, 2019. Right, so it went from PennyMac Corp. to PennyMac Loan Services, LLC. Plaintiff alleges that the defendant defaulted under the terms of the note on December 2018, or in December 2018. Plaintiff served a 30-day default and acceleration notice on April 18, 2019. A 90-day statutory pre-action notice was sent on August 21, 2018 by PennyMac. Excuse me, which is referenced in some guy's affidavit and exhibits D and E. The 90-day notice stated, in part, that as of 8/21/2018, your home loan is 81 days and so much behind in default. The 90-day notice also indicated the website of the sender as PennyMacUSA.com. So as you can see, we got PennyMac USA, PennyMac, and PennyMac Loan Services, LLC. None of those are the same name, but there we are. Hang on just a second. Okay, just to help you out if you want to follow along by looking at the documents. So the affidavit is document 30, right, from the list. And then A, B, C, D, E, F are the next, 6 documents, 31, 32, 33, 34, 35, 36. All right, so this Brown affidavit, this is 30. And then we got 6 sets of exhibits after that. Okay, so plaintiff commenced this action on June 27, 2019. Defendant submitted respective pro se answers alleging false claims, ownership, lack of standing, violations of the United States Constitution and New York trust law, and predatory lending. Right, now that was way back in 2019, but apparently they didn't pay any attention to that because they kept on going. Right, so after joinder of the issue, plaintiff now moves for summary judgment and order of reference. There has been several conferences held pursuant to administrative order. During the conference held on January 28, 2021, the defendants were encouraged to seek legal counsel and were advised of their right to file a hardship declaration. So right here, this after joinder of issue, right? Well, none of this stuff up here ever did it from 2019, right? But all of a sudden we got joinder of issue, which means, the issue, whatever the issue is, has been determined. That all happened after he put in the constitutional question. So in support of the motion, plaintiff submits copies of a note endorsed in blank, which basically makes it a check, mortgage and mortgage assignments, and the affidavit by an authorized representative of plaintiff. I want to say something about this note. They've actually altered this note from what they had in one thing they sent to court to what there is in another. They added an allonge to it. There was already one, and they added a second one. And they took out the signature page. So, there is no foreclosure that's being done lawfully. They're all done in fraud because the people that are doing this don't have any standing. Nobody ever lent you any money for your house. You never signed a contract with the bank. Now, back when I was doing a lot of stuff on, mortgages and stuff, I used to talk about this shit all the time, and it's just a never-ending list of things that are wrong, but how do you get something done about it? Well, apparently it has something to do with, saying you have a constitutional question. Right? At least it worked in this case, and so I hope somebody goes and tries it again, just as simply as this guy did, and we'll see what happens. All right, so defendants cross move for summary judgment dismissing the action with prejudice. Now, again, this is way back in 2019. We're in 2021 now. Defendants argue that plaintiff lacks standing to commence the action as they did not enter into any contract with plaintiff. The plaintiff acted fraudulently, engaged in predatory lending practices. At the last conference held July 26th, the court again advised. Right, so they're making all these accusations, and all the court keeps saying is to seek legal advice. The Joneses were given until August 9, 2021 to inform the court if they wanted to make further submissions with the aid of counsel. On August 9, 2021, or 2002-21, I don't know if that's a mistake or not, but there it is, 2002-21, the Joneses requested additional time to pursue legal representation. The court granted the application, giving the defendants until September 15, 2021 to make further submission. On September 14, 2021, the defendants filed a notice of constitutional questions. Well, look at that. This submission appears to be directed to the New York State Attorney General's office and is not responsive to the motion pending before this court. Right? So it's not an answer to the motion. It happened before you put the answers in, which is what constitutional questions are. And she wants to make it sound like it's directed to the New York State Attorney General's office, when in fact it's directed to the court and served on the New York State Attorney's office. But, that's what she wants to say, because when she gets down to her decision, it won't be because of the notice of constitutional questions, but that's why she did it. So, right, what she's going to do is point out the errors of the plaintiff, right? So this next section here in the discussion will tell you everything that plaintiffs are doing wrong in New York in a foreclosure. Right? In order to establish a prima facie case of entitlement to summary judgment in a residential foreclosure action, a plaintiff must submit proof of existence of a mortgage, note, and evidence of default. Mortgage, note, and evidence of default. Right? And then she says where it came from. In addition, proper service of a RPAPL 1304 notice on the borrower is a condition precedent to the commencement of a foreclosure action, and the plaintiff has the burden of establishing satisfaction of this condition. All right, and she's showing where that came from. So thus, the plaintiff must tender sufficient evidence demonstrating the absence of material issues as to its strict compliance with the RPAPL 1304, law, statute, whatever it is in New York. Blah, 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 blah. And failure to show strict compliance requires dismissal. Right? So all this has already been determined in all these other cases that she's quoting. Here, the plaintiff has failed to establish prima facie case that it strictly complied with the statutory conditions precedent to the foreclosure. Right? So she's going to make the reason she's dismissing the case the fact that the plaintiff didn't comply with this particular statute in New York. Has to do with giving a 90-day notice. And she's going to say everything there is about it, right? The date of default stated in Schedule E of the complaint and the affidavit in support of plaintiff's motion is at odds with the date of default set forth in the 90-day pre-action statutory notice. Thus, the 90-day notice required by RPAPL 1304 is defective on its face as it fails to notify the defendants of the correct default date. Consequently, plaintiff has failed to establish defendant's default and compliance with the 90-day pre-action notice statutory requirement. In addition, the sender of the 90-day notice is identified on the letterhead as Penny Mac, and its website identified as pennymacusa.com. Right? That's in the affidavit and Exhibit E, neither of which matches the plaintiff's identity. right? That's not the name that's on the frickin' document, like the complaint and so forth. Thus, plaintiff has failed to establish that the sender of the 90-day notice was the plaintiff or had the authority to act on the plaintiff's behalf. Indeed, a party who claims to be an agent of another bears the burden of proving the agency relationship by a preponderance of the evidence. The required content of a notice to RPAPL 1304 is very specific and service, therefore, is a mandatory condition precedent. Plaintiff's failure to demonstrate strict compliance requires dismissal of the action. Right? All this has been determined in other court cases, so she's just quoting all the cases that the stuff is in. Let's see. Notice required by RPAPL 1304 contained factual inaccuracies. Defendant's cross motion should have been granted as plaintiff failed to raise triable issue of fact. That was for this case up here, Hudson City Savings Bank versus DePasquale. So although defendants, right, in this particular case, failed to cross move on this issue, the court can search the record and grant judgment. Right? So, the defendant didn't bring this up, but this is the reason that the judge is going to go ahead and dismiss the case. Right? Although failure to comply with RPAPL is dispositive, the court nevertheless addresses the issue of standing in event plaintiff recommences the action after proper compliance with 1304 and uncontroverted evidence of the date of default. Defendants contend that Mears has no ownership interest in the property and therefore could not transfer any such interest to plaintiff. Defendant misunderstands the basic legal tenets of standing. Right? So we need to stop and think about this, that because the failure to comply with this rule or this law, right, the plaintiff committed fraud. And this is through, a different agency than the court. It's through, like the Treasury, I guess you would call it. We'll look at where it is exactly in a second. But, this is where they're not doing the RPAPL 1304 notice properly. And so it never should have got to court in the first place. Right? And now she's saying defendant contended that Mears has no ownership interest in the property. Now, how many people have tried to use the Mears angle as their thing to complain about in court? And, she's saying that, that the defendant misunderstands the basic legal tenets of standing. So, a plaintiff establishes standing in a mortgage foreclosure action by demonstrating it had possession of the note at the commencement of the action. Right? So whoever has the note is the plaintiff. Or to be the plaintiff, you have to have the note. Either a written assignment of an underlying note or physical delivery of a note is sufficient to transfer the obligation, and the mortgage passes with the debt on an inseparable incident. Thus, plaintiff established standing by demonstrating that the note was in its possession at the time it commenced the action, as evidenced by its attached copy of the note endorsed in blank to the complaint at the time of the action was commenced. In addition, in support of the motion, plaintiff submitted an affidavit of its representative and copies of the note endorsed in blank. The copy that the plaintiff put in doesn't match the copy that's endorsed in blank on the complaint, right? They've altered the frickin' documents and assignments of the mortgage. Defendant contends that Mears has no interest in the underlying note. However, Mears is not the party seeking relief. Quit trying to make it Mears. Here, the complaint and plaintiff's submission in support of the motion established that an assignment of the note has been effectuated by physical delivery of the note to the plaintiff before the action was commenced. Moreover, the mortgage was validly assigned to the plaintiff prior to commencement of the action. Accordingly, plaintiff's motion for summary judgment and related relief is denied. Defendant's cross motion is denied. And upon searching the record, the court grants summary judgment to the defendant, dismissing the action without prejudice. Right? Well, if it denied both parties' motions, then what was it searching the record for? Right? I say searching the record because we asked the judge they had a proper oath of office. And there isn't one. The court need not reach the parties' remaining contentions in light of this determination based on the foregoing. It is hereby ordered the plaintiff's motion for summary judgment in order of reference is denied. It is further ordered the defendant's cross motion for summary judgment dismissing the complaint with prejudice is denied. Ordered that upon searching the record, the action is dismissed without prejudice. This shall constitute the decision and order of the court. Right? Because she doesn't want to acknowledge the fact that it was unconstitutional. She's just trying to dismiss the court and go hide under a rock. But basically what she did before she went and hid under the rock was she threw the frickin' plaintiff under the bus. So let's go look at a few other things now. Hang on. Yeah, it's Department of Financial Services, pre-foreclosure notice filing information instructions. Now, we're not going to read this whole thing, but you're going to see that this is a 3-part filing process where the 90-day foreclosure is just the first part. And then they have to do a file of a lis pendens and file within 30 days of entry, judgment, foreclosure, sale, da-da-da-da. So one of the things we're going to do is file a complaint with these people, right, the Department of Financial Services, that the plaintiff committed fraud. Right? It was a malicious prosecution. Because what we're trying to do now is get to the plaintiff's liability insurance. Because if a case gets dismissed, then it's a malicious prosecution. Period. Well, how do you get paid? Well, we could try to put a complaint or try to do something back into the court case, but the judge already said, the thing's closed. She ran away. So, do we need to appeal the case or whatever? I don't know. Maybe what we can do is go to the Department of Financial Services, which is like going to the exchequer in English common law and saying that, the plaintiff violated the king's law, and in that you've been damaged, and, you want to file a claim against the plaintiff's liability insurance. But, that's to be determined in the future. Okay, so this is document 30, which is supposed to be the affidavit done by Brown. But as we can see, there's no state of or county of it. This really wasn't done, period. Right? There's no jurisdiction it's done for. It's got a name in there. It says he's duly sworn and Penny Mac Loan Services, here and after Penny Mac. Yada, 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 blah, blah, blah. Plaintiff service loan, possession of the original note, which possession was confirmed and was in possession of the same at the time the action commenced, right? So he's saying they got the note. Copy of the original note, endorsed in blank, by way of a lodge permanently fixed thereto, along with a copy of the particular business record that I reviewed and relied on, maintained, and described above in paragraph 3, and evidence in confirming the date of the plaintiff's possession of the original note is annexed hereto as Exhibit A. Let me go find that real quick. All right, so document 31 is Exhibit A, and this is supposed to be something to do with the activity, which, they have everything blanked out, so it's hard to say exactly what all this is. We'll come back to that in just a second, but let's go look at the note. Don't know who Black Knight Financial Services is. First time they've been mentioned. But there's loan numbers blanked out. No, blank, 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 blank. Right, so here, I, some attorney at law, do hereby certify pursuant to some law that I compared the foregoing with the original and have found it to be true and correct. Well, this dude just committed a perjury. Right, because here's the note, which, so now this is this is what the lender is putting in, right, the plaintiff, And we're going to compare it to the note that was put into the original, right, as document 1, which was the note, the summons and complaint. So I'm pretty sure these first 2 pages are the same, right? They look pretty much the same, but it says page 1 of 3, right? Go down here, yeah, page 1 of 3. Okay, we'll go look at page 2. Yeah, page 2. Yeah. Right, 2 of 3. Same with this one, 2 of 3. And then on page 3 of 3 is where, Shelley Jones, the defendant, was supposed to have signed. But in the exhibit put in by the plaintiff, there is no page 3. But what there is this, allonge, basically, although it doesn't say it's an allonge. But pay the order of Penny Mac Loan Services without recourse, Plaza Home Mortgage Incorporated. Right? So this is what I'm saying. Now that looks kind of messed up because of the way they did it, right? But here's the allonge that's supposed to be on there, allonge to note. Original mortgager, so forth and so on, right? Pay the order of. Without recourse, Penny Mac Loan Services. So if you were to get this document and put your name here, just like they did up here, right, you could cash it as a check. Because pay the order of is a check. So what they're doing is they take your note and they convert it, which is what securitization is the conversion of a negotiable instrument from one form to another. And they're taking your, what used to be private note, right, that's supposed to be given back to you after you pay off the mortgage, and they're converting the damn thing into a bank note and depositing it. Well, once they do that, you can never get your note back, which is why people who pay off their mortgages can't get their note back. They don't have a note anymore. Now it's been turned into a check. And according to this, somebody, Penny Mac Loan Services, cashed the check, right? And then they put it in their account. And so now if you were to cash the check by filling this out, right? This is why you'd want to subpoena the note. Well, then, you could have them pay you. Now let's compare that to this one, right? Because here we got page 3. And then we have this Plaza mortgage. Is that what this one said? Let's go back and look. Right, this is a completely different allonge. It has nothing to do with this one that was put on here. Right, note allonge, which just has pay the order of with a blank, that's where she should be able to sign. And without recourse to Plaza Home Mortgage. Right, so you should be able to do exactly what these people did. Here it says Plaza Home Mortgage, and Penny Mac signed it. Or they put their name in the pay the order of box. That's what you should be able to do here. So, this is super big fraud. And this is, go to the financial people and point this out. But whatever that office was, what's that office? Department of Financial Services. Right? Because they have a way to file a complaint in here. I saw it in here somewhere, but that'll be in the next video. So, yeah, that's what's going on. Let's see what else they did. The note was signed, secured, personal knowledge, just Penny Mac, yada. I don't know if there's much more we need to look at because that pretty much covered it right there. A copy of this notice and the particular business records I reviewed, relied on, maintained. All right, that's all in D. So all these things that are supposed to have been done, he's talking about in this affidavit. Let me see. My review of records maintained by, and there's nobody there, reveals that within 3 business days of the mailing. Right? So one of the things supposed to happen after they send you the 90-day pre-foreclosure notice, they're supposed to send a notice electronically to the superintendent of banks in the proper form, including information required by statute. So one of the things you could ask, this office here is, did that ever happen? Ask them for a copy of the certificate or the certification from the lender that they provided you the document that they're supposed to have provided you. And there you go, right? PennyMac Loan Services, signature, yada, 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 and then it's signed in Texas. Well, you can't use a notary in text from Texas and New York unless you have a certificate of authority from like the Secretary of State of Texas saying that Amy Yakov is actually a notary of Texas. But beyond that, this company here that we're talking about is supposed to be a California company. So why are they using a notary out of Texas? It's just the crazy ass stuff they do. Right? So this is another important part right here, that the 90-day pre-foreclosure notice to the borrowers as described above. The notice is required to be filed electronically with the superintendents of bank in proper form, including information required by statute, was filed as required by both 1306 and the superintendent. A copy of the said filed 1306 notice is annexed to Exhibit F. Let's go look at that real quick. All right, a copy of the said file 1306 notice is annexed as F. So where is F? F. Right, here's F, which is 36, right? Exhibit F. This is number 36, and right, this was filed by PennyMac Loan Service LLC. All right, now let's go back real quick and look at affidavit. Let me see. No, the judge. What did the judge say? The judge said the sender of the 90-day notice is identified in the letterhead as PennyMac, and its website identified as PennyMac USA, neither of which matches the plaintiff's identity. Right, so she said that's an Exhibit E. All right, so here's that notice that was sent to Shelley. It says PennyMac, like they say. Here's the address, right? That's California. It's not Texas. All right, this is the notice they're talking about. And then somewhere here it talked about, there's the, contact them. Here's this PennyMacUSA.com. Well, none of that matches what they told the state. They said it was PennyMac Loan Services, LLC. Right? So the name of the filer doesn't match the name of the sender. Well, I'd be fraud. Right? So that's, if you got one of these letters and you contact the state, this office here, right? This is what it's going to come back as, and say, well, they don't match. Well, you don't need anything else, right? That's just, the name doesn't match. Now, there's some things that look like they've been blanked out here. I don't know what they are, but, it's really that simple. It's this simple, that the proof of filing statement name doesn't match the name on the document that was sent out to the people that are being foreclosed on. And I'm not going to make it any harder than that. Just it's time to contact the state and say, hey, we got a problem here. So that's, one of the things we're going to try is file the complaint under this Department of Financial Services and see, what it takes to tap their insurance for a malicious prosecution. So more on that later, but I wanted to give this today because it's, it's a big deal. Big deal. And you can find all this yourself on the New York State Unified Court Systems. All right, New York State Courts Electronic Filing. When you get to this page here, you're going to put in this number we've been looking at, which is 2019 52422. Okay, there's so many documents in here that it take forever to try to go through. I'm not going to try to do it, but I do want to show you what he put in. What am I saying? I got to show you what he put in. Hang on, one more thing to look And something I pointed out better in the original video I did on this is, if you look here, right, we're calling this a Supreme Court in the state of New York, County of Dutchess. That really isn't the proper name of the court. Right? The proper name of the court is Dutchess County Supreme Court. Or it isn't, right? Well, that's what this guy called it. So I'd have to go look to see, because, that's normally what they do is they change the name of the court, and the name they put on their documents doesn't really match the proper name of the court, which you would find by, looking them online and so forth. But this is what he put in, Dutchess County Supreme Court. At the end of the day, it was good enough. Right? Notice the constitutional questions. Whereas the third section, the sixth article of the Constitution of the United States mandates that senators, representatives, before mentioned, members of several state legislatures, all executive and judicial officers, both the United States, several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification of any office of public trust under the United States. Right? That's right out of this third section of the sixth article of the Constitution. And whereas an act to regulate the time and manner of administering certain oaths is the first law passed by the United States Congress after the ratification of the Constitution of the United States at large, of the Constitution of the United States. Well, this isn't really written that good, but is the first law passed by the United States Congress after ratification of the Constitution of the United States statutes at large as 1 Stat 23. Right? Constitution of the United States and the statutes at large as 1 Stat 23. Right? 1 Stat 23 is a statute at large. And whereas 1 U.S.C. United States Code 112, statutes at large, contents admissibility as evidence, mandates the United States statutes at large shall be legal evidence of laws in all the courts of the United States, the several states, territories, insular possession of the United States. Question: are the laws the defendant are accused of offending enacted by constitutionally qualified persons? And are the court's judicial and executive officers constitutionally qualified to prosecute and adjudicate the laws of New York? And with a certificate of service in accordance with federal rules of civil procedure, serve a copy of the notice on a New York Attorney General by certified mail. Now, Warren said that, I believe he's talked to the United States, or not the United States, the New York Attorney General, and they have like 60 days to answer or something like that. So we're waiting to find out what happens. But, anyways, he did it all in one document, right? Which is how I had done it on the original. And, as unprofessional as this may look, it was good enough for the court. Right? Now, what was his exhibits? All right, he went to Rule 5.1 of the Federal Rules of Civil Procedure. Constitutional challenge to a statute. Any federal state statute must promptly, right? What we're doing, we're making it against a state statute, just saying, well, is the statute constitutional if the people who enacted it didn't take an oath of office? Because we'll see in a minute what that oath is, but, he got this right off of, what the heck? I don't know what this site is, right? But you could Google the Federal Rules of Civil Procedure and find Rule 5.1 right from the manual, right? Where he took it off a website which it has all this other stuff that doesn't have a damn thing to do with it. But it's okay. It was good enough. Again, that was good enough for the judge. I'm not complaining. Right, here's the laws of the United States. Right, an act to regulate time and manner of administering certain oaths, be it enacted, right, that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following. To wit, I state your name, do solemnly swear or affirm that I will support the Constitution of the United States. Period. Right, that's the oath they have to take to satisfy the 6th article. And that's, officers of the United States and officers of the several states. Well, the judge didn't take that oath. Here's the 6th article of the Constitution. There's the text. The senators, representatives, before mentioned members of several state legislatures, all executive judicial officers, both the United States and the several states shall be bound by oath or affirmation to support this Constitution, and no religious test shall ever be required as a qualification in any office of public trust under the United States. More stuff that, I don't know that needed to be in there, because none of it really has anything to do with what we're talking about. But this part does, right? This is 1 U.S.C. 112, Statutes at Large, where it says the United States statutes at large shall be legal evidence of laws, concurrent resolutions, treaties, international agreement, other than treaties, proclamations of the President, proposed ratified amendments to the Constitution of the United States, therein contained in all courts of the United States, the several states, and the territories, insular possessions of the United States. So, the judge was kind enough to agree that she didn't have the, and then he sent it certified mail to the Office of the Attorney General, just like they said to do in Federal Rules of Civil Procedure 5.1. So I don't know what they'll do with it, but, let's somebody who's in a foreclosure do another one, right? Just submit the damn paper. Right? Go watch the other video I did. So, don't run out and just do like he did. Right? Do your own research first. And how do I get to that thing from here? There we go. Come on now. Right? And go watch Notice of Constitutional Questions and Subpoena. Right? Figure out the name of your court and a few other things you need to figure out. File the damn paper and see what they have to say. That's all we can do. But in this case, the case is, I lost it. I closed it already. The case was, they had a name up here, that they had called it, and I forget what it is. But let me go find it again. Right? The case is disposed. And now we're just trying to figure out, well, how do we capture their liability insurance? Because in a case like this, right, where it's malicious prosecution, right, you get paid per the occurrence. So they can pay $1 million per occurrence, sometimes $2 million. Right? That's just per the terms of the insurance policy. Whether you get any penal penalty or anything, that's determined some other way. But one step at a time. So the next thing is go to these people here and tell them what happened. See what happens next. Alrighty. Y'all have a great day. We'll talk to you again soon.